I'm speaking today from the standpoint of being a practicing family lawyer. Now, not every family lawyer will be trained as a mediator. Those that are trained in mediation may give up the day job and concentrate solely on their mediation, or they might run it alongside their traditional family law practice. I'm currently not trained as a mediator, but I identify that mediation is a very valuable asset. It's a tool that I have in my armoury to help clients reach an agreement. But I think there are some reservations and caveats with mediation. I don't think that it's right for every case. You have to look at the individual dynamics of a relationship, and I think the article by Marilyn Stowe gives some practical examples of situations where people might not be in the best frame of mind to want to talk about money or children's arrangements. But I think to make mediation work, you need to know what your legal rights are. You need to know what you can do to try and achieve a financial settlement or children's arrangements. You've got to feel that you can speak out and say what you really want. You've also got to feel that you can disagree with the other party. So I think mediation is right for the right place, for the right clients, but I don't think you should overlook the court's powers to deal with matters. Parliament has given the family courts the jurisdiction to make decisions where people can't reach their own decisions. And I want to talk about a practical example that's arisen, and that's the Matrimonial Causes Act 1973. Now that provides a statutory framework for potential financial outcomes for divorcing couples. So that could be spousal maintenance, lump sums, sales or transfers of properties and pension sharing orders. And the Act provides a number of factors that the court have to take into account. It can be the ages of the parties, how long they've been married, their standard of living, the resources that are available, but also their needs. Now, there is currently no statutory definition of needs. And it's fair to say that since 1973, the courts have had to interpret what do these factors really mean. And I would have to say that given the wide discretion to judges, there's been a wide variety of outcomes. It can be as simple as, does that judge on that particular day favour the husband or the wife in financial cases? But since 2001, there were a number of high-profile, wealthy families who couldn't resolve their financial disputes, and they had to go to the court. And these cases provided a real impetus to the way that family law has changed and how we should look at matters. In long marriages, these cases said that there should be a yardstick of equality between a husband and a wife. It wouldn't matter that the wife has been looking after the children in the home and that the husband may have had multi-million-pound businesses. At the end of the day, that couple should share the fruits of the marriage. Now, I'm not sure that mediation and relying exclusively on mediation provides a resolution of what's fair, what's reasonable. Now, you could say in this society people are aware of their legal rights and that they're more vocal about expressing them. But I'm not sure the sense of fairness and reflecting the Matrimonial Causes Act factors is necessarily reflected when you're talking about your hard-earned money in mediation, particularly for the more wealthy families. So my concern is that the Matrimonial Causes Act and the cases from 2001 have provided a change in the situation. Wives have never had their needs so generously interpreted since 1973. The reality is that the cases have upgraded women's rights on divorce, and particularly those that have been married a very long time. So for the first time, they've had more capital and more income. And without the court's ability to interfere and impose a settlement on parties, I don't think their financial resources would be as wealthy as they are now. So I believe it is the role of the court to look at society, to say what's fair, what's appropriate, how are we going to value the contributions of a husband and a wife that wouldn't necessarily happen at mediation. Parliament's given the courts the ability to make these decisions, and I don't think that you should necessarily take those powers away from the courts. So my speech it's very short, and because I'm hoping that really the impetus is going to come from Tanya and from Luke to talk about the nuances and the issues around mediation and the court's powers. But my view is fairness sometimes needs to be sought for outside the parties themselves. And I'd like to finish with a little quote from Lord Nichols of Birkenhead, who says, "Fairness is an elusive concept. It is an instinctive response to a given set of facts. Ultimately, it's grounded in social and moral values. They change from one generation to the next. And sometimes I think we need to be led by the court to recognise what is fair and what is appropriate." So that's my view on the take on mediation.
Well, I think mine will probably be shorter than that. I'm coming from a very practical background as HR manager, and I've been involved most recently in workplace mediation. So you could say I've been in HR for 26 years, you could say I've been in conflict for 26 years. It certainly feels like it. I've worked in discipline, grievance, bullying, harassment, stress, hate crimes and a bunch of other adversarial situations. So there's been a lot of problem solving on my behalf, so from my point of view, making judgments and particularly ensuring legal compliance. In the current system, I do think there are winners and there's losers, so it is very adversarial. And I've left really had to make sense of it all when people come to you with their problems, looking at the evidence, of course the balance of probability. And I think even when we've done things in good faith, I think there is room for error in the current system. And even when we establish the truth, sometimes we can apply the wrong sanction. You know, we may dismiss somebody fairly, but really sometimes the other party may have just wanted an apology. So it's about conflict resolution rather than applying sanctions. So I've always tried to deal with things informally where appropriate. So as Michelle says, there's got to be a place for the legal system as well as for informal situations. And it is very much about getting people to talk to each other and getting to the truth. And I thought that was mediation. Of course it isn't, because you're still making judgments and you're still applying your opinions to certain situations. You can go on to formal procedures, which are adversarial. People tend to take positions in the formal procedures, and it can in fact make matters worse. It's very much about presentation of evidence and posturing, rather than actually getting to the source of the problems. I think that actually hinders collaboration. And even if people go down the formal routes, because that goes on and it ends up in tribunal, I still think the parties don't always get vindication, they don't get that long-awaited apology, even if it's a procedural win. That is what it is, a procedural win. So we all know that the legal process, I think, is a given, that it's a lengthy process. I think it's costly. There is legal posturing, and it's based on winning, not fairness. I think there are hard bargaining tactics. Sometimes it is a hostile environment when you go to court. I think there's been criticism of mediation about emotional fallout, but I would argue that anybody that has been to tribunal may find it a stressful experience. Clearly there is always a need for the legal process, but I think we should need to consider a better way of resolving conflict. So, as you can imagine, I'm thinking that alternative is mediation, where appropriate, where mediators are trained and are regulated. So it's not about anybody just coming along and being a mediator. Mediation is a swift process. It can be resolved within 2 weeks, the process, and sometimes the parties can come together and resolve their problems within 1 day. Parties get to have their say at source. It's not via a third party, as happens in tribunal. I think it supports and encourages constructive dialogue rather than a presentation, as I mentioned before, of evidence and witnesses. And it enables people to look at the common ground. I think emotions can be expressed without being filtered by barristers. And it is passing the power on to employees, because it's about self-determination, and it is a voluntary process, which doesn't tend to happen at tribunal. I think sometimes there's support, well, in mediation there is support for both parties rather than lawyers taking sides. And it focuses on the future, whereas I think a lot of grievance processes and court tribunal hearings focus on the past. I think it's about finding an answer rather than exercising legal judgments. And it's about reaching agreement as well without being distracted by other business matters. So sometimes I think you are hindered. You want to comply with legislation, but equally you're so concerned with getting that procedural correctness that you don't get to discuss the real source of the problem. So obviously I can go on all day about the benefits of mediation, but I've got a few others. It promotes employee engagement, which is really important in this current environment, because as we know, it's linked to company performance. And I think it can bring structure to the informal process, because informal can be informal. And I think mediation, you know, it is structured. Okay. So I think the main thing is that mediation has its place. It's not about removing employee rights, because it's an extra stage in the process. But I would argue the point as well that there should be trained mediators, so they know where to signpost things if, you know, they're tripping into the other forums of the legal place. So yeah, so as you can see, I am enthusiastic. I think you hope you can see that I'm enthusiastic about mediation, but there is a slow uptake, and there is a lot of negative response to mediation. So I'm very keen to hear your views on why that is and what we can do to promote mediation. And that's me, and I'm happy to debate and hear your views.
Thank you.
Okay.
All right, well, I'm sorry Simon introduced my view as a defence of the law and a legalist, but I'm going to take the opposite view. I'm going to say that mediators and lawyers are at the moment part of the same problem, and that is the culture of compensation. That's actually a really unfashionable argument to make nowadays, because as anyone who follows these discussions will know, there's been a lot of work done to try and disprove the idea that we exist in a compensation culture. But I'm going to make an argument that we do. And I'm going to argue that out of lawyers and mediators, mediators really are exacerbating the problem rather than making it better. And the key to that is the detachment from the process of any degree of judgment. And I think both the two speakers that preceded me have said that, but in slightly different ways, which I thought was really interesting. But so do we live in a compensation culture? Now, this discussion was quite hot in the early years of the 2000s, but then sort of seemed to fall out of fashion. The research tended to suggest that claims for compensation were declining, that we tended to litigate less, that court activity had been on decline. What I think that seriously overlooked was the impact that compensation culture already had on the culture of the workplace in the past 2 decades. Taking, for example, the first time I experienced this, taking an anecdotal example, I was starting to work in the care sector, and you immediately realised the level of bureaucracy that was required in order to work in that sector. The moment that I approached an agency to do any work in the care sector, I was asked to apply for a CRB check. That was a result of a fear of any kind of legal recompense. So that was my first real insight into how the culture of compensation has really inflicted itself upon public sector life and upon the way that we receive services. And of course that was a result of public inquiry. So I think the key idea is that the CRB system is just one symptom of how compensation culture has impacted, particularly on public services over the last decade. But the most profound example is the NHS. We know that the NHS had to set up its own litigation authority around 2000. We know at the moment that its current liabilities are around 16 billion. We know that it spends in the region of around £911 million a year on legal fees. We know that claims against the NHS for clinical negligence are on the rise. So whilst the government will continue to tell you that we don't live in a compensation culture because general court activity is on the way down, when you focus in on particular sectors, it can become quite a stark picture. And I think I'll throw it open to the floor to give examples of how compensation culture has impacted on people's working in public life, because frankly, you don't have to go very far to hear the stories of people having to cover their backs in relation to litigation, the enormous amount of paperwork that people now have to fill in before they actually get to do their job. The stories abound. So I would put forward the argument that we do live in a compensation culture, and I'm happy to come back and discuss that further. The question, if you agree with me that we live in a compensation culture, then the question arises, well, is mediation a good response to it? my answer to that is a resounding no. Because as much as I loathe the fact that lawyers are involved in more and more areas of our everyday life, I think the influence of mediators is actually perhaps worse. Because what the government have attempted to do with presenting mediation to the public is to suggest that this is a deformalisation of court proceedings. It's a less formal way of engaging yourself in conflict resolution. But I actually think it's the reverse. It's the formalisation of processes which used to be undertaken completely independent of any external professional influence. So when I think previous speakers spoke about bringing structure to informal processes, well, that's absolutely right. Effectively, an entire industry has ballooned out of the possibility of bringing structure to what used to be rather informal processes. So you can see this in all areas where mediation operates. Effectively, what happens is you have a whole new level of external professional individuals coming into a professional setting and effectively structuring what was already taking place before they existed, as far as I can see. They were effectively, mediation is the formalisation, the professionalisation of what used to be very normal, everyday running of businesses and services, etc. So what's the problem with that? What's the problem with having a professional there to structure your informal negotiating process? What's the problem with having external influence on the way that you resolve your conflicts? Well, I think the key was said by Michelle. I think the key point here is that fairness often arises outside of the interests of the parties themselves. I think we can come back to that point because I think that is a central question at the heart of this, is what the courts are for and what mediation does. To bring an example, the reason why mediation exists is presumably because you have tough cases. I'm hoping that in easy cases, I mean this might be a bit idealistic of me, but in easy cases you shouldn't need mediators, I guess, because the legal situation is relatively straightforward. The problems arise where you have a difficult case. You have a situation where both parties aren't entirely sure of their legal position. Perhaps the facts of the case are such that the legal position isn't entirely straightforward. What I would argue there is it's the difficult cases which require the attention of the court. It's the difficult cases where the court's social purpose is enacted. Because what the courts do is enact consistency. And lawyers are bad at a whole load of stuff, and they shouldn't be doing a lot of stuff. But what they do quite well is engage in consistency. Legalism is the practice of ensuring a consistent approach to particular sets of facts. And what I think the danger is with mediation, the real danger, is that the process of resolving tough cases gets taken outside of any notion of professional judgment. I think the problem with that is that judges effectively, when parties come with a difficult case, they are left without any degree of guidance as to how their case is going to be resolved in the long term. Now, of course, mediators benefit from this because they can say, well, this situation remains unclear, it remains fuzzy, the legal situation hasn't been resolved. It's only once the position has been resolved and the legal situation becomes clear that actually the role of mediators falls away. Because if you've got a situation which is legally straightforward, which is what judges do, they bring a degree of clarity to legal situations. They say, in this circumstance, this is what the law says, this is what your position is. That's the best part about judges. That's what courts are meant to do. They're meant to interpret the law and let the public know what their position is with regards to the law. Mediators effectively take that process, put it behind closed doors, shut it away from any due process, and effectively keep results to themselves. So I think that mediators are worse than lawyers, because I think mediators perpetuate a culture of compensation. They perpetuate the idea that people should be covering their backs, that they should be protecting themselves from the threat of litigation. They propagate the idea that processes dealing with conflict should be legalised, not necessarily legalistic, but they should be formalised and structured, etc. That, for me, is propagating the idea that people should protect themselves from litigation and protect themselves from the threat of compensation. And I think that is the real problem at the heart of what we are talking about. So, what's the problem with mediation? The problem with mediation is that it takes a problem, being the fact that we live in a culture of compensation, and arguably it makes it worse, because it fails to bring clarity to the legally difficult situations that people face.
Thank you. Can we thank our speakers? So if you've got any questions or comments, chuck them out. I've got a few, but more than that.
I think we probably all can. I'd like to say that what Luke has said is very complex, and I need to think about it a bit more. But I don't disagree that we're in a culture of compensation, and I think that's partly because we've gone far too PC about everything. But I'm not sure that that's really the greatest relevance here. And I'd like to, maybe the things I'm going to say are going to come back to what you said, but I'd like to go back to Michelle and Tanya and say that you come into this from two very different points of view, from family law, divorce and workplace conflict. And those two are very, very different. But I think the thing that needs to be said about all of them is surely it's better for people to come to their own decisions rather than have decisions imposed upon them. And I think that's, I agree that the law has helped to improve women's rights, and especially when women have been married a long time and then they get divorced and there's an awful lot. And there's a hidden great chunk of women of a certain age who've lost out, isn't there? But the fact is that in workplace conflict, there are, one of the stats is that 370 million days were lost last year in workplace conflict. You can't get the law to come in and sort all those out because you wouldn't have enough lawyers to do it, and the only people who would make a lot of money are the lawyers and the judges. And I don't understand, going back to Luke's, what Luke's saying is why have to come to the law all the time? Because people are perfectly able to make their own decisions. The trouble a lot of the time is that there's a power imbalance, and that's when the mediator comes in, because the mediator is detached. I don't see the detachment as being a problem. I think the detachment helps people to discuss things reasonably and helps them to disagree so that they don't beat each other up or just withdraw, which is what happens in a lot of conflicts. People withdraw, and then in workplace mediation, that's a real problem. And in family situations, when people withdraw, they end up getting divorced, whereas if they'd spoken to each other before, they might not have had the problem. So I think letting people make their own decisions and facilitating them making their own decisions is the basis of mediation. And we should forget about the law unless we absolutely need it.
That's a very powerful argument, and we've had this conversation about the idea of people being free from the state, deciding things themselves. So could you kind of come back on that and perhaps respond to Luke's point about how you then become a new kind of layer of the state, but perhaps an even worse layer?
Well, obviously, I'm not a trained mediator.
Sure.
So I can speak from, if you like, the outside, and I've qualified many, many years ago, so I've seen before mediation became compulsory, before there was pressure if you wanted legal aid to go to mediation. If you want to issue an application to the court, you have to go to mediation. So I remember, if you like, the good old days or the bad old days, depending on which side of the fence you are. I think there is a great difference between workplace mediation and family mediation. I think there are emotions running more highly in family mediation, and you have to think about the emotional dynamics of how that particular couple can function in a room with each other and a mediator. And there is an issue about the quality of the mediator and their ability to manage the process. A good mediator will make a difficult situation better. And I've said, I support mediation. I think it's the right tool, but it's got to be for the right couple at the right time. Anecdotally, I've had clients say to me, I'm a businessman. I do deals every day. I know that I could go into mediation and I can run rings around my wife, but I don't want to have that taste left in my mouth. I don't want to finish our matrimonial finances on the basis of having done a deal with my wife, because I know I could get the deal that I would want, but I don't think that's a fair outcome for my wife and my children. So the culture compensation I don't think applies so much for family law. People have always talked about their own issues, whether they could reach a decision. They've always needed lawyers to help them, guide them through the unclear state of the Matrimonial Causes Act 1973. But I think a mediator does have a positive role for the right couple at the right time, and it can save the judiciary an awful lot of time. We know the courts are littered with litigants in person taking their own cases because they don't have funding. Mediation may well have helped those people not have to get to that stage. It is a question of resuming communication, and I think loss of communication is a very significant issue.
Do you want to come back?
My comments were that mediation is about resolving conflict. It's not about compensation culture. When conflict reaches the cause and it gets about compensation, that's when it's gone too far. We need to be resolving conflict at a much earlier stage. And especially in workplace. I mean, I know you gave the example of married couples and you know, the sensitivity of that and the hurt, but believe me, that can be just as strong in the workplace situation. If you've got an employee or a manager, even whoever is being bullied, it can be very debilitating for those two people. And it's really important that we get in there at an early stage, and it's about actually starting constructive dialogue rather than worrying about compensation. The compensation cultures come because of the legal system. And mediation, in the terms that I'm using it, is about adding to that process. It's not taking anything away from anybody. If mediation doesn't work, they still have all the resources available to them to go through formal procedures and to go to court. So it's not about removing employee rights. It's about being basic and going back to, you know, the good old days when we used to talk to each other and resolve conflict like adults.
See, for me, a lot of what I read and what you've said just seems to be common sense of what employers and employees should be doing in the workplace. But there is a point that Luke's highlighted where everything, so much in the workplace has become overly proceduralised. So where do you think it's all kind of coming from in terms of mediation? Is it a desire to get rid of procedures, or is it to save money by not going to courts or employment tribunals?
I think it's the tribunal system isn't working. I think people are going to tribunal. I think and we're getting there, and then we may be procedural wins, but it's not actually resolving the conflict at the end of the day. It's just literally going and you take your chances when you go to a tribunal. I went to tribunal 18 months ago. I was a dismissing officer. I hand on heart genuinely believed I did a fair dismissal, and we lost the case. It was a judge sitting on his own. That's another debate. You know, and it just comes on down to the day as who is the best person at presenting evidence. It's not about what is right and what is wrong. So if you can deal with things in the workplace before it gets to that stage, then I think that's the best option. Mediation is about, the structure in it is about sitting down and facilitating a discussion between the parties. It's not about being overly formalised, it's just bringing that structure so that you don't favour one party over the other, giving equal opportunity for them to discuss and resolve the conflict themselves. That's all it is really, that's the structure. Other than that, it's a very simple process.
Luke, you were...
Well, I think I'd echo some of your concerns, Simon, but the more I hear, the more I'm trying to figure out exactly what mediators actually do, beyond facilitating and beyond structuring and making notes. And part of me thinks, well, you know, isn't there someone at the company that can already do that? I mean, that seems to me to be the most natural response to the development of mediation. I mean, I'm not best placed to speak on the practical advantages of having a mediator over not. But my concern is that what we are doing is effectively allowing for external professional control to take the place of internal professional judgment. And I think that might be all very well if you're working for, you know, someone who sells computers or whatever. You've got a problem with your pay, or, you know, big company, whatever, that's fine. When you're talking about something like the NHS, it's important to remember that, I was looking at this today, it's quite staggering. that between 2001 and 2012 there are 63,800 cases brought for clinical negligence, and 28,700 of those settled out of court. So if you don't think that mediation and these pseudo-legal processes that have been introduced in order to resolve these claims aren't having a detrimental impact on public services, the NHS is a case in point. Just coming back to the question of why then judgment is important, I think we should realise that we should be limiting people's expectations with regards to litigation. We should not be telling them that, I think there's a real danger in all areas of mediation that effectively prospective litigants are given the idea that, well look, you might as well enter into mediation because you might get something out of it. If you don't, then you can drop it in, throw it in, forget about it, you haven't issued an application. I think going to court should be a big deal, and I think it should be reserved for cases that really need it. My problem with mediation is that it perpetuates the idea that you have more rights over other people than you should do, frankly. And I think it's in that we keep doing it, perpetuate the idea of formalising and bringing in processes to effectively deal with what used to be very informal processes with no need for external professional judgment at all.
But it isn't professional judgment, it may be external, but it's not judgment. There's no control by mediators. They are, as you say, facilitating a dialogue which these people aren't able to do. And yes, there ought to be that in all businesses. But because businesses are surviving rather than spending money on training their managers, the managers don't have the skills to be able to do that.
Well,
so managers knock heads together rather than get people to talk to each other.
Well, I think that betrays a lot of the crisis that we may have in management. It's a problem with management.
But that's an issue. That's not to say mediation is poor or perpetuating it. Mediation may very well stop it in its tracks so that you don't have to go further. But there's no control. Mediators
if anything, that supports what I'm suggesting, that really mediators do very little.
No. It doesn't support that at all.
Well, if you're not... So the question is...
Have you ever been in a mediation?
No, my colleagues have. I said at the outset I'm not the best person to comment on the intricacies of mediation itself.
Or even on mediation.
What I'm making is a political point about if what we're saying is that really mediators are there as facilitators, exercise no judgment whatsoever. My question would be, because of the role that they play, I think, and the research shows that this might be true, that mediators play a serious role in perpetuating the idea of perpetuating a culture of litigation, perpetuating the idea that people have more rights than they do, that job should be done by someone else.
How does it do that? You're making these statements and not saying how.
Well, okay, so I think the evidence is quite straightforward.
No.
The evidence is straightforward in that if you can develop a market out of mediating potential litigation out of litigation, that suggests that there is a problem with the amount of people thinking they can litigate.
True. Leave that in there for the moment, Pauline.
Yeah, I'd like to come back on something that the lady at the front said, actually, referred to power relations and the kind of imbalance of power relations that may be underpinning a lot of conflict at work. And I thought, and I think I'd like to look at it from just a slightly different angle, because I do have experience myself in management, and I do have experience of mediation, and I've been through the process. And I think it's actually the idea of power relations and imbalances of power relations are always, the first assumption is that there's some kind of oppressive relation where someone exercises power over another person unfairly. But in an organisation where someone is managing a particular project or a department, there is also some authority. And I think that there is a problem when authority gets sort of conflated with the exercise of power unjustly. And I think this does happen a lot, and I think that is something that is at the heart of this. Because when the manager is then either not backed up, which is often the case, where they go to their managers or the board or something and they say, we don't want to get involved in this, let's try mediation is always the thing, because it's like a sort of cop-out in a way. And as a manager, often you're under pressure to give way on things that you shouldn't really give way on, because it's easier. And the the mediation there does provide a kind of a bit of a sidestep in the issue situation. I think the problem is that maybe Luke talked about our culture of compensation. I think it is maybe broader. It's a culture of litigation. And I do think I've been, working as a manager for a long time, and I think that it is fairly recently, maybe 10 years, that this culture has become really, endemic. So that it's very difficult to have conversations actually or to negotiate in certain situations because you are afraid that it's all about process. It's all about making sure that you go by the book, and it's very difficult just to have a kind of frank, off the record kind of conversation with someone who's really angry about something because you are covering your back or you're covering the organisation's back. That's where the mediator seems to offer a solution to everyone. And it does seem to offer a solution, but I'm not sure, again, going back to the idea, the underlying problem perhaps isn't addressed. And that could be, for me, I think it's not as a problem of authority and the unwillingness or the difficulty that we seem to have now in actually exercising authority and saying no to people or saying, I don't agree with you to people, which is where the mediation, again, is a sort of softer kind of authority.
Very useful question of authority, just at the back. Then.
This is for everyone. So what impact will mediation have on case law to these speakers?
I come from a slightly different position. I'm a Dutch lawyer and mediator. And I saw this announcement and I thought, well, let's just hear how the situation in England is. And, well, Luke has taken a very interesting position because it's the first time I ever hear that it's the mediators who actually cause the rise in litigation or the fact that people are having more conflicts. My experience, at least a Dutch experience, is that it's basically people are not talking to each other anymore. And yes, indeed, they do need facilitators for that, and those facilitators are mediators. But where you're wrong is that the mediators cause that themselves, I think. Mediators act on the society itself, and in society itself, people are less able to discuss things with each other. It's also the lawyers who have stopped discussing things. It used to be a thing for lawyers where and excuse me, I'm a bit slow in English, of course, but lawyers used to have our bylaws as lawyers in the Netherlands say that you should always try to solve a case outside of court. But you see and you notice that a lot of lawyers don't do that anymore. Lawyers themselves are not able to call up another lawyer and look at a case independently, calmly, and say, let's resolve this and let's bring our clients back together. And that's where it all starts. I think that you're right with the compensation society. At least I recognize that in the Netherlands. I recognize the problems of too much litigation. But it's not the mediators that cause that, it's society itself. And mediators bring only a solution with facilitating these talks. And seriously, if you would like to see how that functions, it's very strange indeed to see that a mediator doesn't do much and at the same time does a lot by just listening, because that's where it all starts.
Could you just expand a little bit about that experience in Holland of people not talking to each other, and what I gather you're saying is a useful role for professional mediators to step into that, because there is an argument that would say, isn't that process of professionalising what we should be doing normally a way of diminishing our capacity to do it spontaneously, that you have to all the time call on a professional to come and do what you should be doing normally anyway?
To a large extent, I think that you're right. But that's why you always also see that, for instance, the Dutch Mediation Institute has put up several programs, for instance, in schools and in a lot of neighborhoods in the country, where they have mediators which work for free, which are even students, to actually train people to talk themselves, and they at a certain point get out of the conversation and let people talk themselves and negotiate themselves. But apparently the art of doing it yourself is what was lost, is getting lost, and we have to teach people that. But that's that, and again, probably. And I think that you should do both. You should teach people this, and you should have mediators. Why? As a lawyer, one would say I shouldn't need them. But as a mediator, I've seen how many people are just completely focused on having their way. It's also that since maybe it's the rise of internet, that since we have internet, everybody can look up anything he wants. There's a website for everything. And on each website there is a truth. And in each website there is, on each page you can read, these are my rights, this I can get. And in the Netherlands there is this, especially in labor cases, you have this specific formula where you can calculate how much severance pay you can get. And everybody knows it. And everybody comes to a lawyer and says, I have a right to get that when I'm fired. But in the end, they're probably fired for a reason. So if they go to court, they don't get that severance pay. But then they do want to have this court procedure. And there are too many lawyers who say yes to that because they make money of it. So yeah, it's a society problem, I guess.
I'm concerned about two aspects of all this. The first one is the fact that it all costs, all of it costs, whether it's mediation or law and so on. It also has social and emotional costs, which are added into the situation. And so people who are managing this, whether they be lawyers or mediators, have an issue about the damage that their clients may be doing to each other, and of course, socially what they might be doing. And it seems to me that that is an important consideration. And if you have somebody like, if you have a negotiator like me, who can turn the temperature up deliberately to exploit that situation, then you have a situation where you increase the level of conflict. Mediators are trained not to do that, but if we hand it back to the people, I'm quite willing to lay on some courses in negotiation. That's one aspect of it. And the second thing is putting things right. Now, I know from one study that I did and one participant observation I did in the NHS, that there are potentiality for things going wrong in the NHS is extremely high. And the staff know about this and the patients don't. If you go into a maternity ward, they will all say, what a wonderful service we've got. And the staff will say, but for the grace of God. Now, if you do my participant observation, or recently small operation that I had, you could see the same sort of thing. I could see the same sort of thing. Taking a sort of health and safety work sort of time. What are the risks of the situation that that we have in this situation? And should I play my card to minimize those risks, or should I play my card to get out of this place as soon as possible? That was a choice that I made. You see. Now, but remember, you see, I know about health. I know how to do risk assessment, and I know how to raise the temperature, and I know about the emotional commitment that people have. Now, all of those things play a part in these conflict situations or semi-conflict situations. I want to know whether the costs of that and the actual monetary costs of it are worthwhile.
Thank you. Speakers, if you want to come back on any or all of those, but particularly intrigued by this issue of a lack of or a losing a sense of authority in work, but echoed here in terms of professionalising skills to talk to each other and mediation. But come back on anything that you like.
Well, let me talk as a family law solicitor. And most family lawyers are members of Resolution, which used to be called the Solicitors Family Law Association. We have strong codes of ethics that say we must keep the heat out of matters. We are not there to write provocative correspondence, to wind matters up for our own purposes. We are there to achieve a result so that these parties feel. Practical example, I often say to clients, don't you want to feel that you can actually sit at the top table of your children's wedding? And rather than think that one of you can't go to the wedding, you have to have a business-like relationship after you have resolved disputes, be they be in relation to how often you see the children, how much money you're going to get, what sort of house, is it a 4-bedroom or 3-bedroom on the best street. At the end of the day, you have to have an ongoing relationship, particularly where there are young children. So that is the ethos of most family lawyers today. We are not here to wind up a situation to earn more money. We are here to achieve an outcome at the best possible time and the best possible cost. But there will always be cases of individuals who have very strong minds. And you can give a client advice, they can choose not to take it. We are there to try and manage our clients as best we can with the expectations and the cost. And sometimes it will actually be cheaper to say, we're issuing an application to the courts to manage the process, because the matter will drift on, and there will often be more money spent in letting a matter ramble on than saying to the court, you impose the timetable for these parties to comply with, the court impose a settlement at the end of the day. So I would say from my personal experience, I am not there to rack up as many bills as possible. I want job satisfaction, and part of my job satisfaction is achieving an aim that the parties settle and they can move forward themselves.
So you're not all bloodsuckers?
The sharks are circling.
Do you want to?
Yeah, I'd like to add that I think we are losing the ability to talk to each other. I think part of that is the legal profession that has given us this conversation culture. And I think there is a need within the workplace to help people to have those conversations. Now, I thought I was doing mediation prior to the mediation training. And it has been really reassuring to get people together and facilitate a conversation in a safe environment for them and get a resolution. In terms of cost, I'm part of a government-funded pilot which is trains 20 small companies in mediation skills, and then with the anticipation of mediating for each other's companies free of charge. And there are, hopefully that's going to continue when the pilot finishes at the end of March, so that we'll be doing free mediations. I'm also a volunteer community mediator, and I went to a Northwest mediation conference last week, week before, I think it was, and we were having this debate and we were saying about the essence of mediation, how we all felt it was a really good thing, but the number of mediators at that forum are all doing it on a volunteer basis because they believe in mediation. So I think, yes, you can claim fees for doing mediation. You know, I would love to do some private work myself. You know, I'm not saying I'd love to pay my mortgage, but equally a lot of mediators are doing it voluntary, and there's a lot of work on the back of mediation on non-violent communication and just getting people talking. So yes, there is money to be made, but I would argue that most mediators are looking to improve conflict.
So you've been kind of pioneer of the government's mediation scheme?
I've been accepting, part of a government's funded pilot, looking at whether mediation will work within the workplace with the view to reduce the number of claims that are going to tribunal. So it's very much at the pilot phase, and we believe it's been very successful. Where we are falling down is that there is this lack of uptake from mediation. A lot of people don't like the word mediation, so if we call it conflict resolution. If you say, I mean, I have dealt with it in the workplace. I've brought people together, quite heated discussions, and I said, would it help for you to sit down and talk about it? Didn't mention mediation, and I've had fabulous results from that at a very early stage level of conflict, but they've gone away saying, well, that was great, and I've done follow-up afterwards, and it has worked in those circumstances, not in everything, you know, but it does have a place.
But after the pilot, where's it going?
We're going to continue as a network. I've got 3 of my colleagues here off the network, and but we just need to look at that now as where it's going, how we can carry that model forward, but we're very enthusiastic to do that. Yeah.
And I want to pick up this point about authority, but first, just a quick another piece of anecdotal evidence. The most emails I receive from my friends when they want legal services, them confirming that what their management tells them about what is a good deal for them is true. So I'll get a document through and they say, well, can you read this through? I'll say, well, it's offering you $6,000 to leave the company. And they'll say, well, yeah, but is that a good deal? I say, well, do you want the $6,000? And they'll say, yes. So do you want to stay in the job? No. Well, then it's a great deal. The point being that they're very keen for someone external to give that seal of what is an objectively right answer, when often there is no such thing. But just that relates to the point about workplace authority. I think that's what the rise of the mediator shows us, is that on the one hand we have a problem in managers being intuitively distrusted. We have a problem with employees consistently thinking they are being mismanaged and being, you know, screwed over. But I think the most interesting part of that is that it extends to the mistrust which is inherent in the judiciary today, which is profound, I think. The mistrust of the public and the government in judges to make decisions is quite remarkable. So, taking as an example my own field, criminal law, judges, when they make decisions now, are so heavily governed by statute, they will often say when passing a sentence on someone, I would love to give you a lesser sentence, but I can't because I have to send it to you in accordance with a guideline. They say I'd love to give this person a greater sentence, but I can't because I'm restricted by a guideline. The factors that they're allowed to take into account and the factors they're not allowed to take into account are all listed in statute for them. So basically, in the criminal courts, the judge is basically guided to the right decision because there is this significant distrust of criminal judges in making any decision whatsoever. That plays out also in the family courts, which is actually where we were talking before, is where I found the most disturbing developments with respect to the lack of authority and the lack of respect for the judiciary, the lack of any respect in their judgment. Because what you have at the moment are these people called Kafkas advisors. And Kafkas advisors are basically social workers employed by a pseudo-government department to go in where there is a dispute over a child's welfare and to act as the child's advocate, basically, to prepare a report on behalf of the child to present to the judge. And in the pilot scheme, 70% of cases, the judge just followed what the Kafkas advisor said. So you'll have the lawyers for the mum, the lawyers for the dad, and then this employee of the government coming in and basically deciding the case for everyone. And I think that's really, really disturbing, frankly, especially when you consider that Michael Gove is the person in charge of Kafkas, and he was the one who said we should be bringing more troubled young children into care. You can see very quickly how that role might become politicised. I think that's deeply problematic. And I think it's part and parcel of a trend with respect to the judiciary where we say we can't really trust anyone to make any authoritative decisions. And when the people that you are mistrusting are judges, it really limits their power to have any purchase whatsoever. How does that relate to mediation? Well, I think in a climate where people are desperate for third-party validation of their decisions, in a climate where people are intuitively mistrustful of their managers, in a climate where workplace authority is on the decline, and in a climate where the government doesn't trust judges, where there have been cuts to the courts, of course you are going to create a new profession in mediation, which is effectively a softer version of a judge. I mean, I'm sorry, you can phrase it in any way you like to say you don't do anything at all, that's fine. But effectively what is taking place, you are setting up, you are replacing litigation with a softer, sort of more touchy-feely approach to resolving conflict. And that makes a lot of sense when you don't trust the processes that you've set up in the wider society and when you don't trust the people you work with.
Does that resonate with you? Because I'm really keen to understand where the impulse for mediation is coming from. And in some of the readings, saving money away from court seems to be a bit of a driver. But Luke is putting forward a wider societal...
It's a significant driver. I'm currently sort of undergoing divorce, and I went to mediation last year. I went to 3 sessions, and the kids went along as well. And I think I've got a wide circle of friends, and nobody sort of turned around to me and said, go to see a family lawyer. Nobody did that. However, when I did go to mediation, I felt as though there was nobody in my corner. And in a way, I felt as though, because I was a vulnerable, if you like, I wasn't the one who ended the marriage, and it was a shock to me. And Michelle talked about the man running rings around the woman. Well, there was a little bit of role reversal going on, okay? Because my wife is, she's a professional woman, very phlegmatic, good at managing conflict, and I was a little bit all over the place, and I sort of got shivered along to go to mediation, and I saw financially that was obviously very, very appealing, and I couldn't help I felt very uneasy throughout the whole process, and even now I can't make up my mind whether I sort of got shafted a little bit on one or two things, but I did have that feeling that I didn't have anybody in my corner. And a good example would be, I think, in terms of one of the things that happened was that towards the end of the second session, when I thought we'd actually got most things boxed off, my wife pulled a bit of a googly, and she said that she wanted more than 50% of the equity in the house. Now, I bought quite a lot of money to the house when we first started off as well. Now, I know that things move along and so on, but I felt as though I thought all along we'd have like 50% of the equity. She had a good job, she could get a mortgage, and I could get a place and get a 3-bedroom place for the kids. And when she threw that in, the mediator sort of said, well, she's suggesting 60-40, yeah? How about coming down a bit, yeah? And I said, well, and actually, I was just shocked, so I just said, I want to finish it there. And I didn't want to continue because I just genuinely couldn't. Next time I went back and I had time to gather my thoughts, I had a bit of a go at the mediator. And I said that I felt as though that she was, I felt I was in a pincer movement, you know, and I felt I had 2 professional middle-class women and me. And I actually said to the mediator, what do you keep looking at me for? And I also, and then she ended up like sort of moving from side to side like a tennis match, and it was a bit of a farce. And then eventually, I said to her, look, I want 60-40. And then my wife was saying, well, hang on a minute, that's not fair. And I said to the mediator, well, look, what about, why didn't you step in and say, you know, that you're automatically assuming that 60-40 is a start-off point. Yeah, so I actually, and I had to come down to 55-45, and she actually suggested that to me. And I just found as though I felt as though that perhaps, even though mediation seems to be the grown-up and adult and sensible thing to do, I actually couldn't help thinking that I could have done with somebody on my side.
Very useful, this gentleman.
The story of this gentleman is very, very recognizable in the sense that, well, to be honest, it doesn't sound like he had a very good mediator. To be very direct, because the whole idea behind a mediator is that he doesn't give this sort of questions or advice. He should only ask, and I see Luke already that he thinks, yeah, what does he do then? Well, he says to you, look, if you are insecure about this, you should now go and ask a third party to advise you. Because I am not the one who's going to advise you. I'm here to help your process and to make sure that you talk to each other. And that's again, you can say whatever you want about that. That it might be that the mediators jump into that to a gaping hole in society where people don't talk to each other anymore. But that's what's happening, and that good mediators help to resolve these issues and help you to talk about it and say to you, look, if you're insecure, please go and find an advisor. Bad mediators go and put pressure and become actually part of the negotiation process themselves. And therefore that, I've just learned, we have the gentleman in front of me who's better at that. So.
Do you want to come
Well, I agree.
But can I just ask, as people talk about mediation, mediators, if you could kind of point to how they should be validated or how they should be regulated or accredited, because you've had a kind of discussion that was obviously a bad mediator, a good mediator would do this. So
I felt there was nowhere for me to go actually afterwards, you know what I mean, in terms of feedback, any sort of, because I would have done if there was any sort of channels to go through. So for example, even from the start off, she met with my wife and I met with a junior partner. And I just, and I told her that I thought that was wrong, and it was a bit like she was sort of, you know, there was no way for me to go in terms of being able to feed back into any process, any regulator, if you like, to actually say, actually it wasn't a fantastic experience based on A, B, C and D.
I agree with the colleague here that it didn't actually sound like mediation. It sounded closer to negotiation. And obviously you were in a very difficult position. And if you're in a position like that, you don't feel that you can go and argue and ask, well, are you being regulated? Have you been trained properly? Because you don't know, because you're in a very emotional situation. But yes, mediators, actually anybody can call themselves a mediator, but mediators do need to be trained, and there is fairly extensive training for mediators, and there are professional organisations, and there are 3 or 4 different professional organisations in this country that mediators can belong to, but they don't have to. And the people that take on mediators need to look for that and make sure that they do belong to a professional body. They do have updated CPD all the time. But to go back to your situation and experience, yes, that's a dreadful experience, because mediation is it fairly new in divorce? I don't know how new it is, no? And yes, there will be poor mediators as well as good mediators. On the other hand, I'd like to say there are good lawyers and poor lawyers. And I was very badly advised by a lawyer and did okay on my own. If I'd gone to mediation, maybe I'd have done better, but I struggled because of a lawyer I was with, and I reached a point where I was about to take out a complaint against them and just decided, oh, I can't be bothered, I'll just go away. But, you know, in that situation, people are in an incredibly emotional situation, and they need to know that that profession is solid, and those people have been trained and belong to professional bodies.
Yes.
Are silly questions allowed?
Yeah.
Yeah. To go from personal to global, where does a peace talk sit in this picture?
Very good question.
And does Tanya want to join in at a peace talk? Because they all say negotiate, don't they? And sorry, that's the wrong term.
I mean, mediation would be involved at any conflict. It's about, you know, people have underlying needs. And when we get to formal processes or when the conflict escalates, it goes into positions, and actually people, I want this and I want that. And really what we actually do in mediation is explore the common ground. So at any level, whether it's wars or anything, it's actually getting down to those discussions, moving away from those positions and discussing the common ground and getting down to what it is actually people are needing from those situations. So,
and how do we become a war needing? A peace talk?
A peace talk. Well, you do non-violent communication, and I think, you know, it's the good qualities of a mediator is to being impartial, non-judgmental, and listening, and having a genuine desire to help those people resolve conflict. You know, I'll go back, I've been in HR 26 years, and I would have, before the mediation training, I thought, oh, this will be a breeze because I'm a mediator. Oh, how wrong was I? Because I was so used to, you know, helping people in my own way, resolving conflict, but I was watching that tribunal that was coming up, you know, making sure that we couldn't say that and we couldn't document that. And I was being fair, but hand on heart, I've got, you know, I'm employed by a company and I've got to keep them compliant. And it's, you know, it's been a lifeline for me, mediation, because I've done such a lot of dismissals, redundancies, grievances, and I'm getting tired of it. And I can actually help people now resolve conflict. we were talking about, what do mediators do? Well, the beauty is in the simplicity. You do sit there, and it's hard work because you facilitated something, but it's them that's coming up with the decision, and you actually go away, you've no notes, there's no legal compliance, because they've done it in an honest way and resolved something. If it doesn't work for them, then they've got all those rights to go through the formal procedures and go to tribunal, and I would encourage them to do that if they don't resolve it, but let's get talking.
And a view to accreditation, where do you think that should be heading?
I think it should be accredited. We're accredited by the Open College Network, and there's different training providers that will train you in mediation, but I think it needs to be regulated by those. There's a few bodies linking or coming up now to Professional Mediators Association, Civil Mediation Council, College of Mediators. As a network going forward, we're looking at how we position ourselves. So we're looking at our best, we're going to investigate all those options to see where it's best for the network and how we can apply that for our company. So, but it is really important that it is regulated. Sorry, I've not mentioned Smile, sorry.
Come back to 3-4, but you wanted to...
It was really just to pick on what I said earlier, that I still believe you have to have legal knowledge and legal information supporting that mediation. You need to know what the possible outcomes are if you want to bypass the mediation process or it doesn't work and you have to go to court. If you want to give away and make concessions at mediation, that's from a position of knowledge, not from a lack of understanding about the process. So a mediator is not there to provide independent legal advice, and I strongly recommend that anybody undertaking mediation really still needs their advice before they go.
Luke, did you want to come back?
Well, I have to. The more I listen to this, the more I'm persuaded that if a society would be better without a certain class of professional, then we should probably look at what role that profession is doing. And I think that mediators and lawyers fit into that category to some extent. I think we have too many lawyers, and I think the problem with mediators is that all it does is it creates an additional layer of professionalisation, which frankly we could do without. I mean, you see the comments in the room, I'm now, having not experienced mediation before, I'm now more baffled than ever before about exactly what it does, because on the one hand, it's very passive, doesn't get involved, doesn't pass judgment, doesn't exercise any judgment. But on the other hand, it's heavily regulated, got to make sure you cover your back, got to make sure you're going through the right processes. I simply don't see how those two things can properly exist. The problem is with the anecdote that we've heard, is that what happens is parties go into this under the illusion that it's a neutral and fair process. And my worry is that for all these mediations that are going on behind closed doors, if the situation is that you're not passing any professional judgment whatsoever, you're just letting the negotiations unfold, and really what you're doing is lending a veneer of objectivity to the process. If your presence doesn't bring anything, any degree of professional judgment, then all you are doing is providing the parties with an illusion that they've got a fair result. And frankly, I think if that's all you're doing, then not only could we do with fewer lawyers, but we could do with getting rid of mediators.
Quite an interesting discussion. I'm really struggling, like you said at the beginning, to get my head around this. I'm surprised that Luke said at the beginning about that the people were denying that there's a compensation culture, because to me the compensation culture was very obvious, and it's very much a sort of where there's a blame, there's a claim, a sort of running away from personal responsibility to blame someone else, and it sort of denies human agency to sort out your problems yourself. And so just, but I thought it was very interesting what you said about the authority being diminished in some way. I just wonder whether that's happening across a lot of professions, whether it's the judiciary, whether it's banking, whether it's teachers. There seems to be, in teachers, they have classroom assistants at every level. You know, in hospitals, it's nurses taking on more responsibility of doctors, and it's like, we don't trust the lawyers, and there's a cheaper way of things like an austerity viewpoint. Let's get a mediator who can cut through that. But what I was concerned about something that you said, Tanya, was that a mediator could come in without that would allow the motions to come through without being filtered through barristers. But I would have thought in that sort of the whole problem is that if people have got a conflict that they're both emotional and they've got personal stakes, that what you do need is a sort of clear-cut, objective and rational outlook. So,
yeah, I think where
Come back.
yeah, it's a couple of questions. If Luke could expand on the relationship between compensation culture, how do you counter that? Because to me it's a really big problem that everyone, you know, if you have an accident, you're encouraged to say it's someone else's fault, make a claim, and people see it as a way of making a fast buck rather than getting on in life through hard work and graft. You know, it sort of undermines that.
You, then back to you. Yes, Jack.
Yeah, it's may I make my points on the my background as a lawyer and a mediator. So it's I feel perhaps some of, you know, I can make these points. I mean, my position. I mean, what you said, Michelle, about the I would totally agree with your last point. I mean, I as a mediator would be completely uncomfortable in a situation where, in a serious kind of family or business dispute, where I felt the parties had not at least touched base with a lawyer to see where they stood. I mean, I think a good mediator should really be able to pick that up straight away. I mean, parties shouldn't, I mean, in serious matters, should not be even going to mediation until they touch base with a lawyer, in my view, and to see where they're. And I'm saying that as a lawyer. I mean, the problem with the regulation, yes, I agree. There is an issue with the regulation. We've got the SRA. If there's an issue for complaints, they deal with our complaints. But in mediation, there isn't really that kind of a body. There's a lot of bodies out there that offer, you know, you can join up to. I mean, it's very interesting. I was in your position a couple of years ago where I wasn't really sure of this mediation, what was it about. And I mean, I've sat in mediations as a lawyer advising a client, but also as a mediator, and it's interesting to see the dynamics of what goes on in a room. And sometimes lawyers are part of the problem in a mediation. I mean, one of my colleagues says to me, all this conflict resolution, this mediation, it's all part of alternative dispute resolution. And what it also stands for, some lawyers joke, is a drop in revenue, ADR. That's what lawyers say to us, because it means people talk to each other, they're not needed, and there's less letters sent. One final point on the NHS. I mean, I know you said that there's a large number of cases which are dealt with through through NHS litigation. As a claimant lawyer, having litigated on cases against the NHS, I can think of 2 cases that if the NHS had just apologised, that's all the clients, or well, one of the clients would have perhaps just forgotten about the case. An apology and a small donation to a charity would probably have got it. So, I mean, I think clinical negligence disputes have actually a lot to benefit from mediation. But I mean, I take on board this chap's experience of mediation. I mean, that's completely unacceptable. And to be tried to be bullied into that's completely against the ethos. I mean, I would take it to last point as regards the conflict resolution in a large scale. I mean the benefits of mediation. I'm from Northern Ireland. I mean, the Good Friday Agreement, massive mediation. So it was, relatively successful. Still a few things to be ironed out, but things are a lot better in Northern Ireland than they were. So I mean mediation. You got to get yourself along to a mediation course. You got to get your firm to pay for you to go to a mediation course, because I think as a lawyer you'll be a better lawyer if you're involved in mediation as well.
One sentence reply. Your background legally, is that commercial?
It's a mixed, some commercial, some criminal, and some part. It's a bit of a hybrid, but a late bloomer to mediation. And I mean, we're part of an organisation called SMILE. I mean, I'd love to make a living out of doing mediation, but I'll do it anyway because I like doing it. You know, it's just, we enjoy doing it. So.
Yeah.
I'm quite naive to this situation. I'm not connected with law or anything like that, but a point that sort of has come to me listening to all the discussion is looking at the wider point of what we think of as fairness. And it seems, Michelle, you were talking about how fairness and values sort of change throughout generations, and also touched upon how some divorces can end up sort of unfair in the views of the state. It wasn't 50-50 sort of in sort of what the Marriage Act was saying. So it sort of the question comes to me, do we want fairness whereby the two parties involved are happy with the outcome and they walk away, in which mediation seems to be going towards that? Or do we want almost state-judged fairness where it goes to law and goes to lawyers to cast their judgment? And I think that's sort of, to me, that was the big two-sided thing. Do we want two people to come together and walk away and happy with what's happened? Or if the state thought actually the wrong decision happened, should they get involved? And that was just something that came to me.
Okay, speakers, I'm going to pile a little bit more pressure by getting 3 more comments.
Yeah, it follows on from that, in that there is a contradiction between conflict resolution and whether something is right or wrong, or fair or not fair. I mean, I would never want to submit myself to a mediation process, because I always think I'm in the right or I'm in the wrong. And I don't want any third-party mediator telling me whether I'm in the right or I'm in the wrong. I'd rather have a judge to make that decision. You know, so for me, it's a fundamentally problematic process to submit myself to a mediation process. And surely both parties cannot be willing to submit to a mediation, because if they're both willing to negotiate, there wouldn't be any need for mediation in the first place. So where does the authority come from of the mediator?
No. Thank you. Gentlemen.
Hi, I think society is gradually getting more complicated all the time. Things are changing. I think the legal system is extremely good for formalising the rules within society at any one point in time. But as it gets more complicated and things change quickly, I don't think we could possibly put everything through the courts. In that respect, I think mediation plays a very good role in terms of helping people reach agreements without going through a very bureaucratic legal system, which I think it would be untenable to run everything through that. I think it's right that mediators must have some knowledge, or at least the clients must have some knowledge of what their rights are, because mediators shouldn't be there to mediate bad decisions. They should be able to help people reach and understand each other's positions and find a good solution. But I find it, and the fact that society is becoming more materialistic all the time is why we're getting so many conflicts. People are demanding more and more rights. I think over time that will be redressed as people start to care more about the environment and each other. They start learning about emotional intelligence and each other's needs more. But I did find it somewhat shocking for anybody to say that mediators were causing the problem when they're actually trying to help cope with a more and more complicated society.
Oh yes, just taking up that point, mediators wouldn't dream of actually, or shouldn't dream, of actually saying who is right or who is wrong. It is about allowing 2 people or 3 people or however many people to come to that agreement themselves and decide whether they can work together, be a family or whatever it is, to actually understand what each wants from the other and to listen to each other. And it's that listening that provides the structure to it. And all we do is actually facilitate that listening by allowing people to take it in turns, helping them to understand what is being said, by feeding back to each other what has been said. And so giving people the opportunity to really understand what the other party is saying and what they're understanding by what you're saying.
Coming up to...
Can I come back on that?
Yeah, yes.
That's the problem I always had with marriage, because it's, why should my private relationship become a public relationship? Why should it be a concern of you or anybody else what my private relationship is with another person? You know?
Okay, last 3 questions or comments I think at the moment. So, Paulie,
Well, one more, yeah, I have one more.
I'll be really quick then, because I think, you know, what I was going to say was said, this whole business about, if something is really serious, it's a really serious dispute, then you want a judgment on it. If it's not really a serious dispute, then why are you going into a sort of process with it in a way? Are mediators therefore connected to the law? Are they separate from the law? Are they just people who are giving people good advice and saying, don't go down that road, it's not really serious, your problem? I don't know if they do that. And the peace process mediation is very interesting because there you have a mediation process in a really serious dispute. It's a really serious dispute between people which has now gone into mediation. And I wouldn't be quite as optimistic about the outcomes of that. I think what's happened is that people get to accept things as they are, but no one actually comes out and says, you're right, you're wrong, and there isn't a judgment made, and the thing just goes on and on, unresolved. And I think that mediation, I don't see how it, I'm with Luke on this one, I don't really see what it does in terms of a legal process. I can see what it might do in terms of making people, you know, behave better to one another, and that's a great thing. But in terms of actually coming to some sort of resolution, I don't quite see it.
Yes.
You were saying who is the authority in mediation? In marriage, a couple give each other authority over each other. It's an agreement that they have. And I think in mediation, a mediator helps them to see, perhaps a little bit more clearly than they have been doing, that that authority is still there and they can still affect each other in a more beneficial way than they are doing currently.
Okay, any very last questions or comments? And then the speakers are going to come back for 2 or 3 minutes each.
In the end, I don't know how it is in England, but I guess nobody's beating you to go to mediation. It's up to you if you want to have a party involved in your relationship. That's up to you. And that is what basically mediation is all about, and that is what mediation does. It's to empower people to resolve their own conflict, whether it's big or whether it's small. And how do we do that? How does that function? That differs from each and every mediation to every other mediation. Sometimes you listen very carefully and you summarize much more. The other times you get much more involved and have other interruptions. But it's about empowerment. And the idea behind it is that it's fair. What is fair is what's fair between people. It's not what the state thinks is fair, it's what you think is fair, because it's your relationship, it's your employment situation, it's your life, and it's not the law that decides what your life looks. Bear in mind when it goes bad, sorry. It's not the law that decides what your life should look like, or a judge. It's you.
Okay, speakers, you've got a shed load of things to come back on. Did you want to come back on one thing about?
Well, it was just to say, you're talking about lawyers being involved in mediation. There are different types of mediation, and obviously it sounds as if you're doing commercial type mediation. In family law, at the moment, then the lawyers don't go into the meeting room, although there are discussions underway about having more lawyer assistance through the mediation process. But mediation is a tool that is available just as much as going to court is available, lawyer-led negotiations and direct discussions between parties. I think a common theme that we've heard tonight is that we have lost the ability to communicate. Now, if you are able to resolve your differences at an early stage, and I'm talking here about family mediation, if you're able to resolve your differences at an early stage, that you salvage from your relationship the ability to move forward, to deal with the wedding situation, that's great. But there will always be personalities that will have a very different view of I'm right, I'm wrong. And in those cases, mediation won't resolve those issues unless one party will back down and the outcome is unfair to them. So my view is that you have to have the court available to decide the outcome in cases where people really cannot resolve the outcomes themselves on a fair basis.
Thank you.
Okay, Mediation is about giving people a voice. It's giving people the opportunity to discuss their differences with the opportunity for a win-win solution. There will always be a need for formal processes, but there tends to be, when it goes to a formal process, you go into this adversarial procedure, and then it tends to be a win or lose situation. You know, when you get to court, you may think that you've got a voice, but then, you know, you may give a statement. The way it is in employment tribunals now is that you don't necessarily read out your statement anymore. They can be classed as being read, so you don't even get to read your statement. It could be that your nerves will take over, you're not able to read the statement. So you don't always get your day in court. So I think mediation is there to resolve conflict at a very early stage, and more serious cases, it's, you know, a benefit then. But I do think it's to sort of get out of this adversarial approach. When it is in the hands of the judges, yes, they will make decisions in good faith, but there will be a winner and a loser, and it just depends, really. It comes down to how good your lawyer is, really, not necessarily whether you're right or wrong.
Okay, starting off, I didn't say that mediators caused this problem, that they perpetuated it. I finally learned to pronounce that word. They perpetuate it precisely for the reasons raised at the back of the room, that they fail to bring any resolution to the kind of problems they're dealing with. So what I was suggesting was not that this is the mediators are the origins of this problem. They are a symptom of a deeper underlying social trend which we should deal with and not try to professionally manage. How do we fix the compensation culture that we live in? Well, I think part of it has to be a rejuvenation of the idea that professionals know what they're doing and trusting in their judgment. And one such barrier to perhaps one small step we could do is abolishing things like the NHSLA, which in engaging with litigation with the with the litigation association geared towards the NHS, of course they're not going to apologise when you ask them to, because that's an admission of guilt. And if anyone else comes back to them with the same case, they'll say, well, you apologised in that case, you must be admitting liability in ours. So it's precisely because there is this organisation which is geared around managing litigation on behalf of the NHS that you won't get an apology. Not from your doctor, not from anyone working on that ward, not from anyone in the NHS, because they're covering their back to such an extent that that level of human communication is completely gone. So I don't find it for a moment surprising when we fail to get an apology out of them, which is really sad. And just to finish off, I think I want to make a robust defence of human conflict. Human conflict is the stuff of life. You know, we had a whole, you know, most early novels are about people resolving very human conflicts. And it's battles, the kind of battles that are now being taken over and managed by professionals, which form the stuff of life. So going forward, take your conflicts, manage them yourselves, and enjoy them, because it's what life's all about.
Well, I'd like to thank the speakers for giving up their time tonight, and I'd like to thank you for being so